LawWiser. Today we are discussing an interesting concept on anti-suit injunction and anti-enforcement injunction. And this concept has been, discussed in detail in this judgment, Interdigital Technology Corporation versus Xiaomi Corporation and others. To discuss this and all these concepts, we have an expert with us. We have Mr. Zafar Khurshid. He is senior partner at TKC Partners. Welcome, Zafar, and thank you for taking time out for us. So to start our conversation with, Zafar, if you could give our audience a brief background of this case of Interdigital Corporation versus Xiaomi Corporation. Also, if you can share certain facts of the case that would help our audience understand, why these concepts were being discussed here.
I'm happy to be asked and to discuss this interesting case, and thank you for having me. So basically, the real buzz around this case is that it presented a somewhat unique and novel situation for the High Court of Delhi. Essentially, the court had to invent, of sorts, a new kind of injunction. It was what is being now called an anti-suit injunction. And it is the first of its case. And while the court did look at much case law, international as well as domestic, which guided it, in essence, it had to craft out a new relief based on various principles before it. There are two parties that were in this matter: Interdigital Technology, which holds certain standard essential patents. These are essentially patents or exclusive technologies owned by Interdigital that are vital for the manufacture or use of certain products. In this case, being certain technologies that were part of mobile handsets that were being manufactured by Xiaomi, which is a Chinese company. The background was that Interdigital alleged that Xiaomi was infringing its patents registered here in India by using them in their mobile phones. Xiaomi went to the court in Wuhan, in China, seeking for a global SEP royalty rate to be set. Since standard essential patents are, as the term implies, essential to the execution or use of certain technologies, they cannot be, they don't fall under the same exclusivity as normal patents. So the law on SEPs states that any party requiring the use of an SEP can seek for a royalty rate, for a compulsory license in essence, on a royalty rate that can be set by the court if they are not able to negotiate with the patent holder. And these royalty rates have to be set on what is called FRAND terms, which is fair, reasonable, and non-discriminatory. So Xiaomi went to the Wuhan court for the setting of these royalty rates. However, it did not inform Interdigital of this. At least that is Interdigital's case. This was, of course, rebutted by Xiaomi in hearings in the Delhi High Court. Interdigital, shortly after, not being aware of the Xiaomi proceedings, filed an infringement suit in the Delhi High Court. As part of that infringement suit, they sought to injunct Xiaomi from using certain patents that they alleged were being infringed. Xiaomi, on the same date on which notice was issued in the Delhi High Court civil suit, Xiaomi filed an anti-suit injunction suit in Wuhan, basically alleging that by moving the Delhi High Court, the respondent in that case, now being Interdigital, was seeking to make the Wuhan proceedings infructuous. And thus, after several opportunities, the Wuhan court satisfied itself that an order had to be passed to safeguard the interest and the hearing that was already going on in Wuhan. And thus, it passed an anti-suit injunction, essentially stating that Interdigital had to either suspend or withdraw its case in Delhi pending the satisfaction of the royalty rate suit in Wuhan. Of course, by this, and when they first got to know of this order, Interdigital came before the High Court. Now, this is where the novelty of the situation came in. because essentially Interdigital said, you have to give me a suit injuncting the order injuncting me from pursuing this suit. So it became the first anti-suit injunction, or at least that's how it was first termed. There are certain other nuances that came out when the High Court was hearing the case, which we'll come to next.
Thank you, Zafar. That actually helps our audience in understanding all the details of the case, and they will be able to relate it better with the concepts that we are going to be discussing. So that takes us to the next question. If you can explain to our audience, what is this anti-suit injunction or the anti-suit injunction, or also that you call anti-enforcement injunction, all these concepts that have been discussed in this case?
So in essence, the High Court was dealing now with three kinds of suits, and it had to identify which was the current suit actually. The first category of such suits is an anti-suit injunction. In essence, this is where a party approaches one court, which it feels is the correct court or the correct jurisdiction for a dispute between two parties, and it gets an order injuncting the other party from suing or starting any legal action in any other jurisdiction. This is to avoid, for multiple reasons. One, to avoid a multiplicity of litigation. The same case for the same relief should not be heard in two different courts. That goes even domestically, and certainly it's more important when we're comparing two international jurisdictions, because the courts do not want to deal with a situation where there are two conflicting judgments from two conflicting jurisdictions. The second category of suits is the anti-enforcement suit. This is a case where in one jurisdiction, a case has already been dismissed or disposed of with some relief being granted or some order being given. And an anti-enforcement suit is when the aggrieved party moves one jurisdiction stating that that suit should not be enforced in that jurisdiction. For instance, this is here the argument that was taken by Xiaomi's counsel in India, in Delhi, that in fact the anti-suit injunction in Xiaomi in Wuhan had already been decreed in Xiaomi's favor. Thus, it was no longer a pending suit. So what Interdigital was actually seeking in India was an anti-enforcement suit. And this distinction was sought to be drawn because they argued that different principles apply to an anti-suit injunction as to an anti-enforcement injunction. So in comparing these two suits and trying to see how they fit into the peculiar factual matrix of this case, a sort of hybrid or new category emerged called the anti-suit injunction. In essence, an anti-suit injunction is simply one court stating that we are not recognizing or enforcing an anti-suit injunction order. So in that sense, it is actually an anti-enforcement order. That is what happened here. The Delhi High Court, looking at the peculiar facts, including the conduct of the parties in the proceedings in Wuhan, as well as before itself here in Delhi, as well as looking at the actual considerations taken into account by the court in Wuhan, as well as the aspect of territoriality of subject matter. In my opinion, this was quite key, because patents, like most intellectual property, are come under national territorial jurisdiction. That is to say that IP has to be enforced within the territorial jurisdiction of one particular state. It is not an international law. Thus, the patents in question, the SEPs, being registered here in India, obviously, as was argued by Interdigital and accepted by the Delhi High Court, the correct court for any dispute over these patents, the Indian court. That was a key factor, and obviously the final and certainly not last factor to be considered by the court was the principle of comity, which is, to break it down in lay terms, It's the principle that one court or one nation will respect the decisions of another nation, provided, of course, that they do not infringe upon that nation's sovereignty or public policy.
Great. This actually does explain a lot, especially about the concept and what the court considered. In fact, that was also going to be my next question. If you could sum up those key principles that the court considered while, deciding upon these concepts.
The High Court noted that Xiaomi, when it came before the High Court at the time of the filing of the civil suit, nowhere alluded to the fact that it had filed the royalty rate proceedings in Wuhan, even when it filed its reply to the civil suit in Delhi. And that supported the case of Interdigital when it said that before this order was passed against it in Wuhan, it was not served of the application by Xiaomi for setting of the royalty rates. In essence, what it alleged was that Court of Wuhan had passed an order ex parte, that is, without hearing Interdigital. This is one of the key factors that a court looks at when looking at whether or not it should give an anti-enforcement injunction. So various factors, some of the other factors being where the order, where the proceedings were conducted either too fast or with undue haste, or where an order was procured under fraud, or where the aggrieved party did not know of the order or had no means of finding out about the order. So this was a key factor for the Delhi High Court. That's the conduct of the parties. Then come the considerations of the Wuhan court. The Wuhan court seemed to be influenced in passing its anti-suit injunction. First of all, of course, by the fact that it felt that the respondent Interdigital had been given several opportunities and was choosing not to appear before it. Second, that it had accepted Xiaomi's argument that Interdigital had filed the Delhi High Court proceedings in order to infructuate or frustrate the proceedings in the Wuhan court for setting of the royalty rate. And then, of course, a factor that is always in the minds of a court, the possibility of conflicting judgments, the issues in the two courts overlapping. These considerations, however, were not accepted by the Delhi High Court. The Delhi High Court found that, in essence, the substance of the two disputes was completely different. The Wuhan court was taking up the matter of what was the global royalty rate to be paid for access to the standard essential patents, the SEPs. Whereas the action in India was an infringement action against the SEPs already being used by Xiaomi. Interdigital had not alleged that every single one of its patents was being used by Xiaomi, but rather only certain specific patents. Whereas a royalty rate for SEPs tends to be set on the bundle of SEPs. So that there itself there is a fact that certain parts of the dispute were not overlapping. Secondly, the fact that a suit injuncting Xiaomi from using the patents did not in any way frustrate proceedings in a Wuhan court for setting the royalty rates. This again shows that there was a difference in the actual subject matter at the root of the two separate proceedings. Finally, of course, territoriality, as we've talked about, the fact that these were Indian patents, and thus any suit for injuncting against infringement had to be raised in India. So, for example, Interdigital could not seek an injunction against Xiaomi in the Wuhan court to ask them to stop using their patents, because they argued, and what the Delhi High Court also felt is that them being Indian patents, India was the proper place of jurisdiction. So these, amongst others, are the several factors that persuaded the High Court that this was a case where the High Court had to intervene and state that the anti-suit injunction could not be enforced in order to stop Interdigital from essentially pursuing a right that was open to them under the constitution in India. So I'd like to circle back to one more point on that. One of the specific reliefs that was granted to Xiaomi by the Wuhan court was that they ordered Interdigital to either, as I mentioned, suspend or withdraw the proceedings pending before the High Court that had been filed, the civil suit. The High Court noted that there is no provision under our law permitting a court to order a party to withdraw a matter. Even as practitioners might be aware, even if when a party voluntarily wants to withdraw a suit that it has filed, it must seek the leave of the court to do so. Because once notice has been issued, the matter is sub judice. It is before a court of competent jurisdiction. And then it is for that court to decide. So indirectly, what the Wuhan court was doing was not just passing an order against a private party. It was passing an order against an Indian court because it was compelling a party to take a matter out of the proper jurisdiction of an Indian court that had already taken it under its jurisdiction. This was another key factor, I think, that influenced the High Court into passing the order that it did.
These are like one of a kind cases. Have there been earlier any instances of such cases, and how do you see this going ahead, especially, in IP where patents is filed separately in each country? So do you see such issues arising ahead more, or this is like one of a kind case?
Absolutely. I think that one of the key factors for the court here was the actual factual matrix. As I mentioned, the conduct of the parties and the conduct of the parallel proceedings in the competing jurisdictions. That was a factor that really, I think, influenced the High Court, and which also lends us to, I think, based on that, we can also assume that while not necessarily one of a kind, these are once in a blue moon cases. It's not necessarily setting some sort of trend or setting some sort of precedent that is going to be repeatedly engaged. Generally, such cases, even as the High Court repeatedly did note, are actually quite rare. Because all courts in most jurisdictions accept certain conflict of laws principles. That is to say that most courts recognize that for a particular suit, for a court to entertain it, it must have jurisdiction, and it must see that a party is not forum shopping or coming to a jurisdiction, to a court that does not have the proper jurisdiction. So actually, such cases are quite exceptional. And generally, where a court is satisfied that another court is the proper jurisdiction for a matter, it does not intervene or interfere in such cases. Often it waits, again, out of the principle of comity, it waits to see what that court says or does or how it undertakes the proceedings. And only then, if at all, will it engage with the question, often at the stage of enforcement.
Thank you, Zafar, for taking time out for us. This was indeed an interesting conversation which helped our audience understand the anti-suit injunction, anti-enforcement injunction, and all these different factors that were actually considered by the Delhi High Court while deciding this case. Thank you again.